Hello everyone. Today we will do the dictation practice of exercise 21, 22 and 23. The speed will be 70 words per minute. For doubts you can write in comment box and you can like, share and subscribe my YouTube channel. So get ready everyone for the dictation practice of exercise 21 first. The corporation has carved out two classes of dependents of the deceased employees in respect of claims for compassionate appointment. The reason for the disqualification of the dependents of an employee who died in an accident involving the vehicle of the corporation is to avoid extra burden on the appellant corporation. In such cases, the appellant corporation has to pay the compensation under the Act and also to provide compassionate appointment to the dependents of the deceased employee. In a case where the vehicle of the appellant corporation is not involved in the accident, the compensation under the Act is not the liability of the appellant corporation. It cannot be said that the dependents of an employee who claim both compensation under the Act and compassionate appointment from the appellant corporation are on the same footing as the dependents of the deceased employee whose claim under the Act against a private owner or an insurance company and compassionate appointment from appellant corporation. The dependents of a deceased employee who claim compensation from the corporation under the Act and compassionate appointment from the appellant corporation from a separate class. It is well settled that though Article 14 forbids class legislation, it does not forbid reasonable classification for the purposes of legislation. When any impugned rule or statutory provision is assailed on the ground that it contravenes Article 14, its validity can be sustained if two tests are satisfied. The first test is that the classification on which it is founded must be based on an intelligible differentia which distinguishes persons or things grouped together from others left out of the group. And the second test is that the differentia in question must have a reasonable relation to the object sought to be achieved by the rule or statutory provision in question. Having held that the classification of the two categories of dependents of deceased employees is reasonable, what remains to be examined is whether there is a rationale nexus of the classification with the objective sought to be achieved by the regulations 4 bracket 3. The intention with which regulation 4 bracket 3 is made is to be obviate the liability of the corporation in payment of compensation under the act and to provide compassionate appointment to the same person. We find there is a rational nexus between classification and the object sought to be achieved by the regulation. It is useful to refer to a judgment of this court in National Insurance Company Limited versus Rekha and others. The question that arose for consideration of this court related to the deduction of salary that was earned by the claimant therein after being appointed on compassionate grounds while calculating the compensation payable to her under the act for the death of her husband. It was held that the salary earned by compassionate appointment cannot be deducted from the compensation which the claimant is entitled under the act. However, it was made clear that the salary which flowed from the compassionate appointment that was provided by the law was liable to be deducted if the employer was the owner of the offending vehicle and thus liable to pay compensation under the act. In other words, the employer who was provided compassionate appointment can claim deduction of the salary of the dependent while calculating if he is liable to pay compensation under the act being the owner of the offending vehicle. The two categories of dependents, that is, dependents of employees who have died in an accident while traveling in a vehicle belonging to the corporation, and dependents of the employees who died while traveling in a vehicle not belonging to the corporation are not similarly situated in respect of their claims against the corporation. They cannot be treated as equals. Therefore, Regulation 4 bracket 3 cannot be said to be discriminatory. In the aforementioned view, we are not in agreement with the judgment passed by the High Court that Regulation 4 bracket 3 is violative of Article 14 of the Constitution. As the respondent has received the compensation under the Act, he is not entitled for compassionate appointment under the regulations. In view of the above, the judgment of the High Court is set aside, the appeal is allowed. The application preferred by the respondent for compassionate appointment was rejected by the corporation as being not maintainable under Regulation 4 bracket 3 of the regulations due to the fact that the respondent has filed a claim petition under the Act. The High Court allowed the writ petition as being covered by a judgment in civil writ petition number 13 of 2014. The appeal filed by the corporation is allowed in terms of the judgment in civil appeal number 7800 of 2019, the Supreme Court of India. The court is of the firm opinion that there is no claim for appointment of the petitioner on compassionate ground by the appellant corporation. There has been several precedents to the case on this point of law. Hence, the appeal not held. Stop, translate this paragraph in English and check from the screen and get ready for the another exercise, exercise 22. Sir, I rise to support the bill as it has emerged from the joint committee, but while doing so, I wish to make some observations generally and also in respect of certain clauses. The objects of the bill, as originally introduced, have been enumerated like this: that a litigant should get a fair trial in accordance with the accepted principles of natural justice. Every effort should be made to expedite the disposal of civil suits and proceedings so that justice may not be delayed. The procedure should not be complicated and should, to the utmost extent possible, ensure fair deal to the poorer sections of the community who do not have the means to engage a pleader to defend their cases. I wonder whether any of these three objectives will be achieved by this bill. Let us not flatter ourselves that this amending bill, as it has emerged from the joint committee, will be able to achieve any of these objects. The Code of Civil Procedure is a complicated thing. It was framed in 1908. We have streamlined it here and there. We have removed some hardship here and there and codified some of the legal decisions, and we have removed certain conflicts in decisions. But that does not mean that the litigant is able to get speedy justice or justice at less expense. Let us be clear about it. I do not blame anybody, but by the civil procedure as it stands, none of these objects can be achieved. I am glad that some of the provisions which have been introduced are really good. They have removed the doubts and conflicts in respect of judicial decisions which had prevailed, each high court giving a different decision about a particular matter that has now been set at rest. For instance, in section 11, there was a conflict of judicial decision whether the decision of a court with limited jurisdiction can operate in subsequent proceeding between the same parties in a higher court. There was a conflict of decisions, and now it is set at rest by saying that the decision of the lower court with limited jurisdiction will operate in a subsequent suit between the same parties in a court with higher jurisdiction. Secondly, it is also made clear that principle applies to execution proceedings. Also, I would like to say that it is good improvement. Section 60 of the original act has been amended, which has given greater concessions to the judgment debt from arrest and also from attachment of his salary. That will relieve some hardships. The Law Commission, in its two reports, have recommended the deletion of this section. The bill, as originally introduced, also deleted that section, but the committee, in its wisdom, found that the notice should be there so that cases which are genuine might be settled out of court by the government so that unnecessary expenditure need not be incurred by the litigant, and also the litigant need not undergo unnecessary expenses and worry. But this section, which is being restored, should not be understood in favor of the government, but the government should deem it a duty to see that whenever a notice under section 80 is received, it should examine the claim of the aggrieved citizen and see that it is settled if it is genuine, so that litigation could be avoided. Otherwise, the government or the government officers never bothered to look into the notice. The litigant is at a loss and he has to go to the court. The purpose was not being served. Now, I hope with this amendment, the litigant will not be driven to the court to file a suit. In cases, of course, where the government feel that the claim is genuine, it could be settled and avoid the litigant from going to the court. About section 100, which speaks of second appeals, they have introduced the words substantial question of law. The wording earlier was on a question of law, a second appeal lie. That is the wording under the existing section 100 of Civil Procedure Code. But they have now put the words a substantial question of law. A substantial question of law should be involved for a second appeal. What does it mean? Suppose the decision of a suit depends on a question of limitation where the plaintiff files a suit and the defendant contests the suit as barred in time. Is it a substantial question of law or is it only a technical question of law? If the latter is upheld, the appeal fails. Therefore, I cannot understand why, on a substantial question of law, have been introduced in section 100. I think really it is taken out of the constitution where it is said substantial question of law involving the interpretation of the constitution. I believe that any question of law which has the effect of deciding the result of the case should be considered as a substantial question of law. Stop, translate this exercise in English. Get ready for the another one, exercise 23. Sir, a tax collected by the state for the state GST naturally has to go to the consolidated fund of the state. There is actually a conceptual problem. Where do revenues collected go? What is the mechanism whereby the distribution is done immediately so that the revenue can be collected and somebody sits on it. That is an important aspect that needs to be clarified. So, that is what I would like that the Honorable Finance Minister to reconsider the amendment number 3 that he has moved. Secondly, that is an important point. You collect revenue. What is the mechanism and what is the time frame within which it is shared between the states and the center? If you don't have that clarity, then how can you collect revenue which does not go into the consolidated fund? That is not permissible under our constitution. That cannot remain in vacuum hanging somewhere, that amount. Therefore, this is a serious lacuna, according to me, that needs to be addressed. Then there is another amendment number 4 that has been moved by the Honorable Finance Minister. Sir, I have with me letters from the chairman of the Empowered Committee of State Finance Ministers, a position that this bill has discussed over the last 2 decades, a position that was occupied by the left front government's finance minister, now occupied by the current finance minister of West Bengal, and a letter also from the finance minister of Kerala. I know letters by the state finance ministers should not normally be read out here. So I am not reading out these letters. Now, both the West Bengal finance minister and the Kerala finance minister, and I think there is a point in which they argue that there has been an issue on the question of the tax levied and collected by the union under clause 2, etc. This is the newly proposed amendment under the same amendment number 4 of the finance minister to clause 10, whereby this amendment, I am informed, has not been discussed in the last empowered committee meeting of the state finance ministers, and it goes against the decision of the empowered committee of 2014, where it was decided that the residual amount in the IGST shall be shared with the states as per the Finance Commission's formula formulated during financial years. Therefore, both the states, the chairman of the empowered committee have suggested that this be deleted and let clause 10 remain what it was as the Lok Sabha passed it. That needs serious consideration, and I would like the Honorable Finance Minister to respond to that when he sums up this discussion. The fourth major point is on the dispute resolution mechanism. Right now, it appears that it is left to the GST Council. They will work out a mechanism. I think a greater thought must be given to that. That mechanism must be spelt out more concretely and in a tangible form at the time when the GST bill is brought for consideration. I am requesting the Finance Minister to do so. Finally, sir, I will end with only one point. This is a very, very serious piece of legislation. We are making a very major radical departure from the revenues collected by the states and the central governments for their functioning. We are making a very major departure from the objectives for which these revenues are collected and how they will be spent. This is of such a major importance that not only the GST bill should come back for consideration, but also all connected with the GST bill must be brought here also for our deliberations. Therefore, they should not be brought as money bills. I myself made an appeal to the finance minister. You are aware that I told you earlier of my interpretation of Article 110 of the Constitution of India. It is a non legal, non lawyer, common sense interpretation. Article 110 bracket 1 says what are the items that constitute a money bill. Article 110 bracket 2 says what are the items that don't constitute a money bill. Article 110 bracket 3 states that in the case of a dispute, the decision of the Speaker of Lok Sabha will be final. Common sense interpretation is that the matters under adjudication of the Honorable Speaker of Lok Sabha are matters that are not mentioned either in Article 110 bracket 1 or Article 110 bracket 2. Only then Article 110 bracket 3 should come into operation. But now what is happening? Article 110 bracket 3 is coming into operation for matters listed in Article 110 bracket 1 and bracket 2. I think that is wrong. But anyway, one of our colleagues has taken it to the Supreme Court. Let us wait for the verdict. In that spirit, I had even said this once before. It means that in our indiscretion or hangover from the colonial rule, be correct now. Stop, translate this exercise in English and check from the screen. Thank you.